Hello. Thanks for joining us. We're proud to offer on-demand webinars for our Justia Connect members. Justia Connect Pro members can also receive CLE credit for select on-demand presentations. Before we get started today, we want to make sure that you're aware that the presentation that you're about to watch is a recording of a live CLE event. While we're confident that this presentation will provide you with valuable insights, there are minor details and instructions that may not be applicable to you as you're watching on the on-demand format. Welcome, and thank you for joining us for another Justia webinar. My name is Mina, and I'll be the moderator for today. Before you begin, I wanted to remind you all that today's presentation is eligible for CLE credit. Please note that to receive CLE credit, you must be upgraded to Justia Connect Pro, as well as stay for the entire webinar. Additionally, if there are any materials that coincide with today's presentation, those will be available for download. You can access those by visiting the webinar page, logging into your Justia Connect account, and then if you scroll down past the thumbnail, there will be a little button that says Download Materials that you can go ahead and click on and get access to those. For all the lawyers here today, I also wanted to quickly highlight the Justia Lawyer Directory as a great way to build your professional visibility. If you haven't already claimed your free profile, you can do so anytime by going to lawyers.justia.com. With millions of visits each month, it's an easy way to connect with potential clients with ease, and we've even recently redesigned our listing pages with a new look and launched a new profile feature, the ability to add FAQs directly on your profile, not only enabling you to answer common questions and show your expertise, but also expanding your reach in the AI search results. Finally, if you'd like to boost your exposure even more, we also have our Justia Premium placements available, Platinum or Gold, to put your profile above the organic listings for your chosen location and practice area. And you can learn more about those at marketing.justia.com. Now, to kick things off today, I want to go ahead and introduce our speaker, Tracy Kepler. So Tracy Kepler is the Risk Director of Control Tracy Kepler, Director of Risk Control for CNA's Lawyers Insurance Program. In this role, she leads the lawyer's professional liability team, is accountable for business results through delivery of risk control services, and designs and develops content and distribution of risk control initiatives relevant to the practice of law. Tracy reviews and directs the evaluation and assessment of loss exposures and the application of risk control policies, guidelines, regulations, and drives the resolution of risk control issues and problems. She also collaborates with the underwriting and claims teams to develop and execute strategies for the profitable growth of the program itself. The webinar that you're about to watch will be about 1 hour, and Tracy will be taking questions, time permitting, from the audience. So if you have questions that you'd like answered at the end of the presentation, you can go ahead and submit those by clicking the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here is Tracy to discuss No Attorney Stands Alone, Recognizing the Complexities of Law Firm Operations and Legal Malpractice Exposures.
Hi, Nina. Thank you so much for that very kind introduction. I really appreciate it. And I welcome all of you to today's presentation. I'm really looking forward to talking about this subject matter because it's not something that we typically think of or even consider when, we're bringing in legal ethics and risk management. And maybe sometimes we're a little self-centered, so we always think of ourselves. But we're thinking about everybody else today, right? Everybody else who touches our practice, who comes into our practice, whether it be internally, externally, and some of the risk around those associations. You know about me. Nina did a great job of introducing me. If you want to contact me, please do so. I love hearing from everybody. You've got my name, my email, my direct line, and my mobile. I'm always available. As I say, what kind of lawyer would I be if I didn't start with a little disclaimer? And what I want to say is this presentation is really legal guidance. It shouldn't be considered legal advice. The comments I'm making, the ideas I'm suggesting, the opinions on which I'm opining represent my personal views based on all of my experience. They don't reflect those of my employer. And then the last one is, this is being offered for educational and informational purposes, so please take it with that frame of reference. What are we going to do for the next hour? What are the kinds of things that we're going to talk about? What is our roadmap? Well, the first thing we're going to consider, and as I said, we're talking about everybody else but the attorneys, we're going to map our legal universe. We're going to talk about who those people are who contribute to, our success and sometimes the challenges. We're going to talk about supervisory responsibility of these peoples, from an ABA model rules perspective. We're going to talk about some vendor management when we're talking about non-legal assistance. And we're going to do, I know you're probably all tired of hearing of this. We're not going to have that much on it, but we're going to talk and touch on a little bit of AI. And does that constitute non-lawyer assistance within the confines of Rule 5.3? You've probably heard this expression, right? You're probably familiar with the saying, no man is an island, from John Donne. I probably should have said no attorney is an island, as I did in the title. And that's where I'm going, right? In the realm of lawyers' risk control, we really do have to modify it to say that no attorney is an island. Practicing law is really a collaborative endeavor. Even if we're solo practitioners, we're working with other people. So it's collaborative, it's oftentimes team-based, and it requires more than that one individual. So let's think about who those people are, or who those things are, like I said, when we're talking about AI. And I think it's probably, for all of you out there, a relatively safe assumption that when you were in law school, studying for your bar exam or applying for your first position as an attorney, during those kinds of things, you gave little or no thought to legal malpractice exposures, insurance, maybe not even risk mitigation, ethics, yes, conflicts, yes, billing, of course, essential, but legal malpractice, I don't think so. Where did your idea of legal malpractice risk rank in those things that you were considering? Do you think you were more likely or less likely to face allegations of legal malpractice or disciplinary violation than those of your colleagues? It's tough, right? And we didn't give it a lot of thought at the beginning. So here, what I'm trying to show you or get you to do is to assess your own legal universe. Recognize where the malpractice exposures may lie, and then address what you can do to avoid encountering allegations of misconduct, malpractice, or disciplinary complaints. Step back for a moment and take a second to consider all that goes into managing your law practice. Who are the people who make it possible? What entities are part of your business? And by extension, touch or implicate the attorney-client relationship. Beyond those that may have direct access to your client files or your client data, who else may touch or implicate or have something to do with confidential information within those files? You can see the potential list, or I call them the cast of characters, who may be contributing to your law practice on the screen in front of you. And I think this list really does reinforce the reality that law firms are no longer confined to the four walls of a law office. If the pandemic taught us that, if nothing else. Even the true solo practitioner without staff is dealing with individuals and entities that are listed on the screen. With these individuals and entities, exposures to legal malpractice risk and disciplinary complaints can arise. And in looking at this list and looking at the people who are on it, think about how all of those listed influence your practice and how they may help, or more importantly for our discussion, hinder or create legal malpractice risk. I've taken this list a little bit further here, a lot of colors, a lot of words, but I want to take those individuals that we were talking about and identify potential legal malpractice practice exposures pertaining to the professionals who interact with our practice. Right? These individuals and entities may affect your practice by failing to provide competent legal services and access to client data, including all of that, juicy personal identifying information, financial or medical records, trade secrets, depending on your type of practice. Um, some of these individuals or entities fall into both categories, but here the stronger designation is emphasized, right? For example, a paralegal has access to client data and may misuse that personal identifying information by stealing their client's identity, opening a credit card. But I think for us, and we like to think that that's rare. For us, the potential concern from a risk control perspective is the paralegal failing at an assigned task, such as, filing a complaint not getting the complaint on file prior to the running of the statute of limitations, or that clerk or that runner or whoever, on Pacer or electronically, who is doing the filing, not getting it in on time. And I think it's imperative that attorneys recognize that they're not the only ones who commit or contribute to legal malpractice risks. In fact, later we're going to see a number of cases where it is those others that we're talking about have actually caused or contributed or were not supervised properly to this risk. It might seem odd, and you're probably wondering why I'm doing this, but it might seem odd to think of these individuals or entities in a negative light. But we know, and I know from where I work and where I live, that human error or a bad actor getting access to client data, may trigger some of these problems. I think we're all aware of the cyber risks and the cyber threats that are bombarding law firms. But we also have to acknowledge those threats that are coming from within, that those who are assisting us in our day-to-day practice may pose a considerable threat both within and outside the office. I want to get into some of the model rules because I think they are key when we're talking about all of these people, both internally and externally, who touch upon our practice. This rule 5.1 is the basic rule for the responsibilities of the partner or the supervisory lawyer, the management committee, the executive committee, the person who is, up here and from everything else falls. And basically that person or the team who has the managerial authority, mandatory, shall make reasonable efforts, and we'll talk about what some of those reasonable efforts are, to ensure that the entire firm has in effect measures giving reasonable assurance that all of the lawyers in the firm are conforming to the rules of professional conduct. Now, when I'm talking about the rules in today's program, I'm talking about the ABA model rules. Again, those are models, right? And each state adopts their variation of those rules. So it's particularly important for you to check what your state jurisdiction's rules are in regard to the rules that we're talking about today. But who are these people, right? Who possesses this managerial authority? Who are we talking about? And I think the comments are instructive in this regard. It's a whole bunch of people, right? It's the members of a partnership. It's the shareholders in a professional corporation. In a governmental agency, it's the people, who have comparable managerial exposure or responsibilities. It also can be the immediate managerial responsibilities in the firm. It doesn't have to be just the executive committee or just the management committee. And what am I talking about when I'm talking about these reasonable measures? What are firms supposed to put into place to prove that they have complied with their obligation in this regard? And I think a lot of it turns on policies, procedures, obviously, that help manage risk or help look at risk from a proactive stance. Having a conflicts of interest checking system, right? That's designed to detect and resolve conflicts, whether it's one person, whether it's a team, whether it's a committee, whether it's a whole division. Calendaring and docketing, right? Having tickler systems so that everyone is on board of not only when something is due or when it needs to be filed, but backing that out a little. So you have some heads up. So you're not that person at 4 o'clock in the morning frantically trying to get things done to get something filed, right? Identifying dates when actions must be taken. Certainly, having accounting software or divisions, bookkeepers, accountants, whatever it is, to manage your client funds and to make people aware when there might be a problem. Mentoring, right? Giving some education, giving some training, giving some learning experience to newer people, who have come on to the firm or people who are just transferring in. Certainly, internal CLEs is a great example of these reasonable measures. And one that's sort of immeasurable, if you will, you can't quantify it, is the ethical atmosphere. Is your firm one that abides by the rules, that takes them very seriously, knows what they are? Or are you in the middle where you're kind of pushing the boundaries to see what will fly, what won't fly? Or are you on the other side of the spectrum where you could care less about the rules? You're going to do what you need to do to win that case or to get that settlement or to finish that transaction for that client. Additionally, with regard to the reasonable measures that you're going to put into place, size and experience really has an impact, right? If you are a small firm, let's say, 2 to 5 lawyers, maybe you're having weekly meetings, right? The discussion about reasonable measures, ethical conduct, it's informal. There's an occasional admonition. You take training together. It doesn't have to be as structured as you may see in a large firm, right? Where they're going to do all of those things that I've just been talking about. Plus, they may have a general counsel or an of counsel or an internal counsel or a risk management counsel, some sort of referral source that less seasoned and, quite frankly, more seasoned attorneys can go to talk about legal ethics issues and to get guidance on which they can rely when they have a question. The second part of this rule, so we were talking about the top, right, the management committee. Now in B, we're talking about any other attorney who has direct supervisory authority over another lawyer. Guess what? You still have the same responsibilities. You need to make sure that those people, those attorneys that you are supervising, you have reasonable efforts in place to ensure that their conduct conforms with the rules of professional conduct. And the last subsection of this rule is almost like the strict liability standard, where you, the supervisory attorney, can be on the hook for that junior attorney, for that person who you're supervising conduct. What this rule says is, look, you supervising lawyer are going to be held responsible for another lawyer's violation of the rules of professional conduct if, one, you told them to do it, right? You ordered it, or with the knowledge of the specific conduct that was happening, you knew about it, you ratified the conduct. Or the second part is, you're in one of these roles and you knew of the conduct at the time. And when we talk about knowledge, we're talking about actual knowledge or that which can be reasonably inferred by the circumstances, right? You knew about the conduct at a time when you could have done something, right? You knew of the conduct at the time. You could have done something to avoid the consequences or mitigate the consequences, but you failed to take reasonable remedial action. Like I said, the C section of this really does create personal responsibility for the acts of another. This is explicit or tacit. As I said, you ordered it or you knew it was happening and you ratify or you don't do anything. And you knew of it and then, look, I didn't do anything. you didn't intervene to prevent, and you didn't take any action to correct the conduct. Moving on to the second part, this is the other side, right? This is the responsibilities of the subordinate lawyer. And this rule is basically saying it's not okay to say, well, I was just following orders, right? They told me to do it. I'm just following orders. What this is saying is, look, you, the subordinate lawyer, the one who's being supervised, you are bound by the rules of professional conduct, notwithstanding you acted at the direction of your supervisor, of another person. But there has to be an out. There has to be an exception. But you do not violate the rules if you act in accordance with your supervisory lawyer's reasonable resolution of an arguable question of professional duty. What does that mean? Well, as I said, the just following orders is not going to save you unless inexperience, being a newbie lawyer, not knowing what the rules are, is not going to excuse your compliance. And, what am I supposed to do if my boss asks me to do something that I think is wholly contradictory or unethical with regard to the rules of professional conduct? What am I supposed to do? Do I have a conversation? Do I go to that general counsel? Do I go to that ethics counsel? Do I refuse to do it and potentially lose my job? A whole bunch of, dire consequences are things that you need to think about when you're put into that position. I kind of like this hypothetical, and I know that we're in a virtual audience, but, answer to yourself at home, because I think it really does give a great example of this 5.2b requirement as well as the exception. And in this hypothetical, you're an associate at a firm. So 5.2b is going to come in, or 5.2 is coming into play. And you are assigned to represent Singe and Sizzle, which is an oven manufacturer, and also Julia Childish, kitchen distributors, an oven distributor in a lawsuit. And during the course of the representation, you've got a lot of questions about this dual representation. I just don't feel quite right here. I'm not sure that all of the parties are on the same page. There may be a conflict. And you talk to your supervisor, who says, you know what, there's not a conflict. And this is why. And goes through an elaborate explanation of why there's not. Maybe there's a waiver, X, Y, Z. And you say, well, that makes sense. So you go ahead and you continue the representation. In fact, your boss is wrong. There is a conflict. But at the time, your supervisor's interpretation of the rules was a reasonable one. Whether they were going through a process under 1.7a, 1 and 2, and then the exceptions under B, it was a reasonable interpretation of the law. So are you going to be subject to discipline here? And the answer is clearly no, right? You are acting, and you did act in accordance with your supervisor's reasonable resolution of an arguable question of professional duty. In the end, their interpretation was wrong, but you still relied on that representation to go forward. And so 5.2b would come into play. The other rule I like to highlight here, particularly given how we started talking about all these other players who come into our world, or our universe, if you will, is 8.4a. And I'm not looking at this rule from the attempt part, right? The violate or attempt to violate the rules. I'm really looking at it at the second clause, right? It's professional misconduct for a lawyer to knowingly assist or induce another to do so, or to do so through the acts of another. And I think it really does go hand in hand with the 5 series that we've been talking about, where you are getting, you can't do it, but you're getting someone else on that long list of people that we looked at to do it for you, sort of going around your obligations and figuring it's okay for someone else. The last rule I want to talk about right here is 1.6 with regard to confidentiality. I talked a lot at the beginning about personal, identifying information, information that can get out there, whether it comes from an external source, those cyber criminals, or whether it comes from an external source, a vendor that you're using, or even an internal source. Another rule with which you have to, play, right, or be mindful is 1.6c, part of the duty of confidentiality. And this rule says it's another mandatory rule, right? A lawyer shall make reasonable efforts, though there are those words again, to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. In this day and age, can we be 100% foolproof? Never get hacked, never have ransomware, never phishing, vishing, spoofing, any of those kinds of things happen to us? Probably not. And many of you have cyber insurance to cover you in those cases. But what can we do? Are there things that we can do, reasonable measures that we can put into place to cover us under this rule, to show that we're complying with our obligation? Of course there are, right? And if you take these reasonable efforts, in most circumstances, you're not going to violate this rule. What are some of those things that we can do to protect ourselves internally and externally? Well, we've got to think about first the sensitivity of the information that we're working with. I mentioned earlier, if we've got a whole bunch of client data, medical information, financial information, social security numbers, birth dates, all those kinds of things, that would be great fodder for the dark web. Our precautions, our reasonable efforts might be heightened. The other thing to think about is, what is the likelihood of disclosure if additional safeguards are not employed? How much is it going to cost to bring in these protective platforms, educational tools, maybe even training or testing on, is this a phishing email? And I love this one. The difficulty of implementing additional safeguards. I think a lot of people, when they're thinking about these other people who touch on their client data or work with them in a firm or collaborate with them in a firm, we want the best, the most sophisticated, but sometimes the most complex system. And when it's too complex, it's onerous to use, people don't understand it, it doesn't get used, and people take shortcuts. So you have to think about something that's going to work for you individually, for the members, and for the members of your firm. Transmitting documents, this goes without saying, slowing down a little bit, asking other people to slow down a little bit. You don't want to be that person who adds that piece of paper, doesn't redact information, and you want all of your team and your staff to do the same. I love this case, the Matter of Lehman case. It's an oldie but a goodie out of Indiana. I guess I know a lot of us keep our files in the cloud. And in this day and age, the likelihood of someone actually disposing of client records in the garbage bin is pretty small. But this case, as I said, in Indiana, came out the action actually happened in 2009. And what ended up happening was Mr. Lehman threw away client files basically in a garbage bin. And these client files contained all kinds of sensitive personal data, social security numbers, there were a lot of financial records there, and he threw it away in the public trash bin, just like the ones you see on the screen. And guess what happened? Before the garbage person could come and take it away, the files were discovered by a reporter, and the reporter had access to all of this information. And of course, the reporter went straight to the Indiana Disciplinary Board to tell of Mr. Lehman's conduct. Another story I will share with you happened actually during COVID, where an attorney was working from home, had files, client files at home that again had personal, sensitive information, and threw them down, if you live in a high-rise apartment building, threw them down the garbage chute. And instead of shredding them or disposing them, in another way, threw them down the garbage chute. And instead of the garbage chute going into the incinerator or into a big trash bin, it emptied out into this big garage floor for everyone in the building and outside the building to see, to gather, to look at, and to later reveal. Again, happened to be another disciplinary case, also turned out to be a malpractice case. just a few other virtual practice concerns that I will bring up and that you would want to bring up with your staff in the virtual age in which we are practicing, right? Things to be mindful of. These are the reasonable efforts. A lot of us are on video depositions, video hearings, video calls with clients, video calls with the courts, whatever it may be, whatever it may be. Conduct a 360 review of your space, right? Look at the walls, look at your desk, look at the bookshelves, look at your calendars. Make sure that there's not client information or file information out there for all to see. Additionally, who else is in the room with you? Right? We're working from home. Yes, sometimes it's our cat. Our cat's not going to tell. But who else is there? Your kids, your spouse, cleaning people, home repair people. Who else is there? And who's there virtually? Thinking about Alexa, thinking about Siri. Is she there? Is she listening? With regard to screen sharing, we've all heard horror tales of, not turning off Teams and confidential information from inside popping up on your screen when you're sharing screens, file names and uploads, making sure that they are, confidence proof. We could have a whole discussion on virtual practice. We'll save that for another day. But what I want to do is move on to 5.3. And 5.3 has actually evolved over time. Basically, when this rule was introduced in 1991, the rule referred to assistants, like ANTS, indicating, individuals like internally, legal secretaries, paralegals, investigators, people inside the law firm. It now reflects assistants in order to acknowledge both the individuals and entities that contribute to a law firm internally and externally, right? As I said, we're no longer confined to the law firm space. And these people that we were talking about earlier may, be working with you, but they're not in your personal or physical space. They're without. What are the circumstances for an attorney who fails to appropriately supervise staff? It can be tough, right? The from a disciplinary perspective, it can be disbarment, suspension, whatever that might be. And you can see your duties, and the language should look very similar. Before it was supervising other attorneys. Now we are supervising all of these other people, and the rules are the same. Not only do we have to make sure that there are reasonable efforts, that all of our support staff and everybody we work with understands what the rules are, but we are responsible for that person's conduct if the conduct involves a violation of the rules, or if we direct them to do it, and additionally 8.4a, or we ratify the conduct, or we could have done something at the time and we didn't do anything. Taking that list we saw at the beginning, I think it's important to show the kinds of discipline and a lot of ethics opinions from around the country that implicate all of those people. The first case on this list is a great one. It's Inri Emery, a case out of South Carolina from 2017. Basically, in this case, Ms. Emery used the services of a non-lawyer contractor who placed all kinds of misleading content on her website and her Facebook page, and then they engaged in the unauthorized practice of law. It was related to a real estate practice as well as a loan modification practice. She was a solo practitioner. She did not have any employees. She outsourced all of this marketing and all of the paralegal work that she was doing. And basically, she never disclosed, anything about the rules of professional conduct to her web designer. And what the web designer did was go and look at other websites, cut and pasted from those other law firm websites, put that material on Ms. Emery's website, said things like she was attorneys, plural, when she was the only one, overestimated her experience. What else did she do? Oh, advertised for services where she had no experience in that area of the law, and she had no willingness to even take on those kinds of cases. In addition, Ms. Emery had a Facebook page, And she had this outsourced paralegal who was working with her. And what the paralegal did was wanted to congratulate those clients who, completed their home closing and would say, congratulations, and then reveal the clients' names on the Facebook page. She also advertised all kinds of discounted rates that Ms. Emery wasn't going to provide. And she was contacting these clients through Facebook and basically engaging in the unauthorized practice of law by giving these clients legal advice with regard to their loan modification documents through the Facebook page. Paralegal, right? It can happen even in advertising or with web designers. It can also happen with interpreters or translators. Typically, we don't think of those people as sort of in our network, but when you think about 5.3 and non-lawyer assistants, you better believe that they're there. Or how about our collection actions? We hire someone, our clients aren't paying their bills. We want to file collection action. So we go ahead and hire a debt collector to help us with that. Or we are running a debt collection business where the people who are working with us are engaging in all kinds of unauthorized practice of law. Another ethics opinion from DC, all about the investigators and what we can do there and how we have to supervise them and their work. Maryland has a great one about supervision of the marketing firm you're using, kind of like Emory in that regard. Or how about your IT professionals? Whether they're internal IT departments or you are outsourcing that work to someone else, the software provider, any of those. Massachusetts has a great ethics opinion there on that responsibility to supervise them. Foreign migration agents, you can see the New York State attorney ethics opinion. And then again, going into the IT world, the computer consultant, somebody you're bringing in-house or even your internal people, great Virginia ethics opinion on the consequences for failing to supervise under 5.3 there as well. So what are we looking at? What are some recommendations to be proactive in managing our risk with these people who touch our law practice? One of the exercises I think we've already done, right? We've identified. We looked at the exposures for each person or entity that is participating with, collaborating with, or contributes to our law firm, both internally and externally. You also want to review and evaluate, or the other word is vet, right? Think about who your vendors are. Look at the contracts. What are they doing? What do they have access to? What are you giving them access to? Along with this vetting comes another R, research. Who are these people that you're bringing in, right? Look at their references. Confirm their educational background. Make sure that they have a license, that they have the experience that they're telling you they do. Review of all the contracts for any vendors that you're bringing in. The training of the staff, right, of the non-lawyer staff. This is one of those, mandated, imperative, reasonable measures that you have to put into place. And then this one, again, sort of immeasurable, right? Sort of this psychological safety, this ethical culture that I was talking about. You want your team, lawyers and non-lawyers, to feel comfortable asking questions, to feel comfortable saying, I'm not quite sure. What am I supposed to do? Or if a mistake is made, bringing it to your attention when you and other members of the firm could actually do something about it to mitigate, to ameliorate, or to assist in going forward. So let's talk a little bit about legal support staff and their risk in this avoidance. I just brought a whole bunch of legal ethics opinions, formal ethics opinions from Colorado about, this duty under 5.3 to supervise legal assistants, UPL, temporary lawyers, contract lawyers. There's also an ABA, really good ethics opinions around non-lawyer assistants, 23506. There are tons of resources out there. And these are ones that I just found about Colorado. Each state is going to have their own. Look at them. Right? They'll give you a lot of helpful information on what are reasonable measures within your state and what you can do to prevent and be proactive with regard to this risk. The other thing I want to talk about is who these people are, right? The law firm staff, and I don't think we often think about it in this way, but we should. Because the law firm support staff really do play an important role in avoiding legal malpractice, right? They form or they do a whole bunch of duties, starting with gatekeeper, right? I think a lot of times we have to say, uh, what we do without that person, right? Our secretary, our paralegal, a research assistant, we may think, oh my goodness, you're a godsend. I don't know what I would do without you. And competent professional staff really do represent an invaluable resource. If you've never thought about the power your support staff has in your law practice, I think you really need to take some time to assess that reality. I mean, who really runs your professional world? One of those roles that these people play is the gatekeeper. It's not quite the same now that we're in this virtual world and there's cell phones and email. But support staff really do act as the selective manager, deciding whether or not a client is going to have direct access to you. There are times, right, where we are so busy that we can't take the call, we can't schedule the meeting that client wants. And as a result, our staff has to explain our inability, get back to them, try to set up a meeting, obviously not answer questions that require legal knowledge or skill, but, have the ability to keep those clients, especially the ones that may take a longer amount of time, from you. They are the gatekeeper in getting to the attorney. Law firm support staff often are in much more direct and day-to-day direct communications with your clients, because sometimes they're easier to reach, or maybe the client's not being billed for speaking with them directly. One of the leading complaints that we currently see in disciplinary matters, I think it's up to 61%, is neglect. And part of neglect, yes, one part is diligence, but one part of that neglect is the communication. I'm talking about Rule 1.4 here. 1.4 requires attorneys to keep their clients informed of the status of the matter and other obligations. And I think sometimes that step often involves support staff, drafting client communications and responding to client questions. Law firm protocol, you have to determine what questions are within the purview of the support staff, and then what questions need to be escalated to the attorney on the file. And training around those issues for your support staff is crucial. Another thing that the law firm support staff does, or are often responsible for, is the critical tasks related to the client representation. Whether it is, confirming an engagement letter is countersigned by the client before anyone's permitted to bill on the file, whether it is monitoring outstanding invoices or timely filing materials with the courts, failing to do that creates a big potential malpractice risk. So those critical responsibilities have to be identified, and those who are empowered to implement them have to understand their importance. And the other thing is, if something goes wrong, they have to feel safe to raise that error, to raise that mistake to the attorney as soon as possible. Another issue is realistic workload. A realistic workload not only helps you as the attorney, but your support staff avoid legal malpractice allegations. If you and your colleagues are overwhelmed with work, you better bet that your staff is as well. And when you're in that circumstance and you're distracted, you're disrupted, you're irritable, you are at the greatest risk, you and your team at the greatest risk for a malpractice error. Certainly, with all the technological advancements that we have, you may not see the cluttered desk with mountains of client files to indicate the overwhelmed employee. But you need to pay attention. You need to think about bandwidth, and you need to make sure that everybody is working together and are not completely burnt out and overwhelmed. The last one is, who in your firm would be the first to know when a client is upset or dissatisfied with their counsel? If you said a member of the law firm support staff, Ding, ding, ding. You'd probably be correct, right? In their role as gatekeeper and providing these standard updates to clients, they are much more likely to hear the first whispers of dissatisfaction. Second, if they're bringing the complaints to the support staff, that complaint has to be addressed. The lawyer needs to know. And so you need to have this ability to speak freely and be comfortable telling the attorney, having that relationship about these types of problems. So I said, how do our support staff fit into this? Where are some examples of malpractice gone wrong when support staff was in play? Or maybe not, it wasn't the support staff's error. It was other people who weren't paying attention to what the support staff were saying. This is an oldie but a goodie, but I think it's really important because this is a malpractice case that involved legal support staff and their alleged error leading to a billion, with a B, that's right, $1 billion claim. It hit the headlines in 2015, but it really does demonstrate the importance of support staff in legal practice. You can see the initial headlines that came out about this issue. If we dig a little bit deeper behind the headlines, and I'm just going to simplify the matter here rather than get into every single fact. Basically, there were two separate transactions. The first was a synthetic lease financing deal in the amount of $300 million. The second was a term lease in the amount of $1.5 billion. And the case involved a paralegal who wasn't familiar with either the lease or the term loan. And when the borrower was prepared to pay off the $300 million synthetic lease, they asked their law firm to prepare the necessary documentation. And, in a tale as old as time, the partner assigned the matter to his associate, and then the associate delegated the work to the paralegal. And the paralegal was responsible for pulling all the SEC filings for the client and to provide the information to the associate attorney. Unfortunately, there were multiple SEC filings related to the client, and the paralegal inadvertently included a filing number that was not applicable to the matter at hand. And as a result, the security interest for that separate $1.5 billion loan was released. Instead of including the two required numbers, a third number was included, and this error wasn't discovered until years later. This simple error of the file number or the number created a huge malpractice exposure. And who was responsible for it? Well, I think as I've been talking about, it's a collaborative endeavor, and that includes a whole bunch of people. Within that firm, it was the partner, it was the associate, it was the paralegal. Everybody was involved in preparing the materials, and they didn't act alone. No one at the client company or the secured party or their respective law firms noticed the error before the filing, but it still turned out to be a $1 billion error. I think you have to think about, and I talked about this briefly, have you ever had a member of your firm, of your support staff, come to you with concerns about a potential error on a file? And if so, how did you respond? Did you listen? Did you talk about their concerns? Or were you like, don't worry about it, and completely dismissed them? Hopefully you took the concerns very seriously and you addressed or investigated their concerns related to the client representation. In this case, if the paralegal had a mentor to seek out or felt comfortable discussing this at the time, perhaps the error may have been avoided. Like I said, in this case, we can only speculate as to what steps may have mitigated or avoided this error. But what ended up happening was the firm set out materials that resulted in the unintended release, and we can see the damage, right? The $1.5 billion legal malpractice exposure. The interesting thing was that years after these first headlines appeared, the court found that the law firm that employed the paralegal was actually not responsible to the lenders who lost their secured interests in the properties. To oversimplify the result, the lenders were not clients of the law firm, and the documents were prepared at the law firm, but they were reviewed. Talk about collaboration. They were reviewed by multiple firms before they were executed, and no one along that chain actually caught the error. Another example, and this goes back to the bandwidth that I was talking about. This is a very overworked and overwhelmed paralegal. For a 2-year period between 2011 and 2013, the paralegal forged the signature of 76 judges on 117 court orders related to the sale of structured settlements. Basically, this was the paralegal solution to an overwhelming workload. And this is not the only time we have seen this kind of conduct. Once the conduct was discovered, the law firm had to notify the court and the clients. It was a disciplinary matter. It was a legal malpractice matter. And I think what this goes to show is that law firms really do need to supervise the workload of staff to ensure that it's manageable and to avoid creating situations that overwhelm, right? And may lead someone to engage in fraudulent conduct when there could be a simple solution. Here, in this case, the actions of the paralegal were completely extreme. But support staff are more likely to make an error when they are overwhelmed with work. Some recommendations for you with regard to the supervisory, with regard to the reasonable efforts that you need to put into place. Right? First, acknowledge support staff as critical to avoiding legal malpractice exposures. Right? If you appreciate what they're doing, how they're doing it, that they're an integral component into the legal services that you're providing, that it's a team effort, that goes a long way to being proactive. We talked about the bandwidth issue, overworked attorneys create overworked support staff, maintaining caseloads to the extent that you can, bringing on extra help. Education, right? Having training, CLE, not just for the attorneys, but for everybody involved. And then this ethical culture, this psychological safety in your firm that actually encourages communications and questions with everybody involved. With the time I have remaining, I want to talk a little bit about outside vendors and client representations. We talked about, internal. Let's talk a little bit about external. For many people, solo practitioners or like Emery that we saw, we are the one person, right? And we rely on others that we pay, contract attorneys, IT, outside IT, whatever, temporary attorneys, whatever it is. We have to supervise them, and we still have to put reasonable measures in place to comply with our obligations under 5.3. 2 great ethics opinions that I will commend to you to consult at a later time. One, it's an oldie but a goodie from the American Bar Association, 88-356, that talks all about your responsibilities in supervising and vetting temporary attorneys or contract attorneys that are coming to your firm. And the second one, a little bit more recent, 08-451, that talks about when you are thinking you're going to outsource, right? When you don't have the staff, but you want to bring somebody in for legal as well as non-legal support services, the kinds of things you need to think of before you bring them in, and the supervisory responsibilities where you are obligated. Outside vendors, are they helpful? Are they harmful? When we think about law practice management, when we think about managing our workload, and when we think about bandwidth, sometimes they are a necessary evil. But certainly, depending on our area of practice and depending on the topic or the subject matter on which you are bringing these people in, you may need to get client consent if sensitive information is being shared. The duty to supervise under 5.3 goes without saying. That's a must, not only for internal but external. As we talked about 1.6C and your obligations under 1.6A, the duty of confidentiality, anything related to the representation. Not only do you know that, but you need to make all of the outside vendors know the sensitivity of the information and how important it is that it stays confidential. Certainly, you need to perform your conflicts checks. before you bring in these people into your team. We have seen some cases of late where it was an imputed disqualification, where there was a conflict issue with either a paralegal or with an outside temporary attorney. The vicarious liability I talked about, that you are on the hook for someone else's failure to comply with these obligations, even if it's a non-attorney. And certainly, this is a subject for a different day, but I throw it in here. The reasonableness of the fees that you are charging to your clients for any outsourcing work that you are bringing in. I like this case as well because it goes to one of these, external malpractice exposures. Here, what happened was it was a process server. In this case, there was a bank foreclosure judgment that was dismissed due to the actions, or I should say rather, inactions of a process server. The judge found that the failure to keep the records of attempts to serve a homeowner actually violated New York's general business law. And, while it might have been a one-time error on the part of the process server, in this case, what ended up happening was the court said, you, attorney, you haven't kept records of thousands of files over a 6-year period. And so you have to be, it's not just you, it's who you're working with, right? It's in assessing your legal universe. Are you certain that those people that are assisting you are aware of what's required of them? So some other good risk control tips to put into place, or things that you can put into your practice when you're dealing with those outside vendors. Certainly, if you have to inform your clients, there may be times when it's impliedly authorized, or you may need the informed consent for these outside vendors. One time that I think is particularly important is when you're storing your data in a cloud. There is nothing worse than your system being hacked, and the first time you're telling your client that all of their information was stored in the cloud was in conjunction with, oh, and by the way, it's all out on the dark web, right? In your engagement letter, you're going to be talking about how client data, how client files, how client information is stored. Certainly, you want to continuously monitor these vendors, update contracts if there are changes in the contracts. Even though you vetted them initially, that doesn't obviate the need to keep on top of them. What are they doing? How are they doing it? Whatever the case. You may want to use confidentiality agreements with these outside vendors. Certainly, reviewing all the work product of the vendor. You can't just say, well, I trust them. I think it's all fine. Same goes with AI. Certainly alerting the client to any billing that you're including with regard to the vendors and the non-lawyer staff. And then, as I said, a lot of these expectations and boundaries and the use of outside counsel or IT or cloud storage or whatever the case may be can be eliminated at the very outset and proactively by putting some provisions in your client engagement letter. So what do I have? Couple minutes. Let's talk about some technology strategies, because again, technology is one of those entities or people that were on the list at the very beginning. On the screen in front of you, I have a whole host of really valuable resources and ethics opinions that you would want to consult with regard to your obligations, of securing confidential information, what you do if there's been an electronic data breach or cyber attack, blogging and public commentary with regards to confidentiality obligations, receiving privileged or confidential materials, and then certainly that old bugaboo, hitting reply all, sending things out that you ought not. One of the things that I think goes without saying with regard to technology and the vendors that you're using, it starts with you, right? And your obligation under the competence requirement of 1.1. The competence duty is the legal skill, knowledge, thoroughness, or preparation required to represent the client. But if you look more deeply into the comments, it really is instructive, saying, look, it's not just that. You have to understand the benefits and risks associated with the relevant technology, and you've got to keep abreast of changes in the law and the practice regarding this technology. You can't, you need to be aware of what it is. Do I need to use it? Should I use it? How do I use it? Will it be helpful to my clients? And then when changes in the law happen, you need to be up to date with it. I've got one more minute, and I hate to give short shrift to AI, but I think it is important in this discussion when we're talking about non-lawyer assistants. Is AI a non-lawyer assistant that we have to consider within the confines of Rule 5.3? How do we supervise the thing, the algorithm? I say it kind of tongue in cheek. Of course, we're not supervising the thing. We're supervising and vetting the output, whether it is our own use of AI, whether it is, a subordinate, somebody we're supervising, whether it is a summer intern, somebody internally, externally. And I think one of the ways that you can go about this, one, is not only supervision, but creating an internal AI policy that really does look at, what your firm's goals are, why we're using this in the first place, a governance framework of who gets to use it, who can't use it, who has access, for what purpose. Certainly education and training goes a long way. Monitoring AI performance. And then also, actions have consequences, right? What happens if you don't comply with the policy, and regular review and updates. Just a few key things to consider before you put AI into your house. Thinking about what you do. Is AI even going to help it? What program should we implement to begin with? And should it be a closed loop system, meaning the client confidential information that we put into the system stays in house? Having that basic knowledge. How does it work? What data is going to train it and help it learn? Protection mechanisms. Do we have this internal policy? And has there been education? Just for your own edification, I have found this website to be outstanding. It's the Bloomberg's website that regularly, and as soon as it's published, updates legal ethics opinions as well as state laws from around the country on AI. It also has task force reports, practice management tools. Like I said, very, very helpful in this regard. A few other things that I will leave you with. When you're thinking about AI, 3 things. First one is investigate. That's the vetting, right? Exploring. Using it, right? It's the end of the blank page. It's useful, but it's not a substitute to your mind and bespoke legal services. And then the last one is we've been talking about, and it brings us full circle back to the beginning, is supervise. Right? You cannot assume that all the content generated is going to be accurate. Who in your firm is the subject matter expert? Who's going to be reviewing? It's not just the attorneys anymore. The clients are coming to us with documents that have been generated by AI and asking our opinion. And as I said, policies go a long way. Couple cases for you to look at, some AI in the headlines, as well as some risk control recommendations around your firm's use of AI. Not only you, the attorney, but the other people we've been talking about who are using it. And with that, Nina, I will turn it back over to you for any questions that there may be from the audience.
Wonderful. Thank you so much, Tracy. And we'll go ahead and move on to those couple of questions that we have just for a few minutes. So this first question is, how can solo practitioners realistically meet their supervisory obligations under Rules 5.1 to 5.3 when they rely heavily on contractors or virtual assistants?
It's so tough, and I hope an excellent question, right? It's when you are all by yourself and you're depending on others to help you because it's just, to manage your workload, you have to outsource. And so I think a lot of these reasonable efforts that I've been talking about so that you can comply with your obligation under 5.3 are some of the things, the vetting, right? If you're going to bring somebody in-house, whether it be a contract attorney, a temporary attorney, a virtual assistant, you've got to do your due diligence. who are these people? What is their background? And really, dig a little deeper. And it's not just the individual, it is the contract that you're entering into for the services that are being provided. It is the constant communication and monitoring of the work that is being done. And it's very difficult because I think for solos, right, not only do we have to provide the legal services, right, we have to represent those clients that are coming through the door so we can keep the lights on. We also have law practice management responsibilities, right? Marketing, bringing in new business, accounting, all those kinds of things. And now Tracy's telling us, you got to supervise and vet the people who are coming to work for you. Yeah, unfortunately, you do. And it's not just the scary things like I've been talking about, the revelation of personally or sensitive information from a client. It's also the unauthorized practice of law. We talked about clients we talked about these staff people as gatekeepers, as, having communication with the clients. What are they saying? Are they giving legal advice? Is it straddling into legal advice? Is it the unauthorized practice? And that's where the training and the education is another one of those reasonable measures that you have to take the time to put into place.
Thank you, Tracy, for that insight.
Okay, one more thing. Invariably, some attorneys, and I've seen it in my disciplinary world where I was for 20 years prior to coming into insurance, unfortunately, the best of us make a mistake, right? We trust that person. We depend on that person. They've never steered us wrong. They've never violated the rules. They've never gotten us into trouble until the time that they do. And sometimes it's really impossible to gauge, and it may happen, and that's why hopefully you have malpractice insurance to help you in that regard.
Thank you, Tracy. Our next question, you shared that example about the associate who delegated to the paralegal and that kind of causing this error. But this person asks, what are some of the most common malpractice exposures that arise from poor supervision of junior associates, and how can firms prevent them?
Well, I'll tell you one, and it sticks with me because I'm sure, one, I'll tell you two. One has happened to me, and although we caught it in time, right? And one, it led to a malpractice exposure. I won't say where, but it was an S, right? It was an S. It was supposed to be payees or, whatever it was. It was supposed to be singular and not, actually, I think it was a D transfer. I think it was supposed to be singular, and the paralegal added an S. And so it included a whole bunch of other parties that weren't supposed to take. Huge. 1S. And even though, kind of like the example I gave, even though multiple people internally, not only the paralegal, but the direct supervisor and somebody even higher, the partner on the file, looked at this, nobody caught the S. I hate to say it, and I would love to say there's a checklist, do this, do this, do this. Sometimes, look, we're not perfect. Sometimes it's just the slowing down. Sometimes it's just the paying attention. And sometimes, look, we trust these people, right? They do good work, but that still doesn't mean you don't look at it. The other thing I will say, the other example I'll give you, and it was horrible. You do everything right? You put it all together and you give it to your administrative assistant, or you give it to somebody to help you with, right? They're the person who's going to file the documents, make sure that the document gets copied, make sure that the document gets uploaded, gets scanned into the system, whatever the case may be. And they attach something that was on the desk. That was an internal memo talking about strategy on a case. We're talking about revisions to a contract that gets added in to the last page or internally with a document production or with a motion. But you didn't look at it. Right? You gave it to that person. You knew they could do it right. They always have in the past. You never looked at the filing until it was too late. Again, some of these things we can't help, right? And that's why luckily we have malpractice insurance. But sometimes the proactivity, right? The education, the training, making sure that all of these people that you work with understand how important they are to the process and that they feel it and understand it as well is critical.
Thank you so much, Tracy. Our last question for today, this person asked specifically about AI. I know you touched on it a little bit at the end, but they're asking if you think that it'll be a possible standard of competence to be able to utilize AI, or
I think it already is.
Yeah.
I think I think it already is. When you look at the breadth of that comment, right? And the comments are advisory only in nature. But I think partly, and what we've seen from some of the cases already, is it's a competence factor, right? And it's not only what it is and what it does, but is it right for this client and am I using it properly? The same thing, just like we did Westlaw, like any other of these technologies that have come along, the same thing is going to happen with AI as well.
Well, thank you so much, Tracy, for your time and answering our audience's questions and for presenting with us. We always love having you. And thank you to our audience members for your participation. We really appreciate it. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier, if you're a lawyer attending today, don't miss out on the Justia Lawyer Directory, a free tool to boost your professional presence. You can claim your profile at lawyers.justia.com to connect with millions of potential clients each month. And you can explore our newly redesigned listing pages and enjoy new features on your profile, like the FAQ edition to allow you to answer common questions and even expand your reach in those AI search results. And if you want even more visibility, we do offer our Justia premium placements, both platinum and gold, to help you show up above those organic listings. You can explore those at marketing.justia.com. Thank you all so much for joining and have a wonderful rest of your day. Thanks for watching. Please complete the verification as prompted by the on-demand platform. If you need any assistance, you can reach Justia support at support.justia.com.